May it please the court, my name is Amanda Lancaster and I am representing Pepsi. My client is asking the court to set aside a default judgment against Pepsi for $1.26 billion. The procedural rules that we are referencing today are Federal Rules of Civil Procedure 55C, which allows the defendant to ask for the default judgment to be set aside based on good cause. And the second is Rule 60B, asking for the default judgment to be set aside for mistake or inadvertence within 1 year of the judgment. As we go through the facts of the case, it is clear that the claimant properly served Pepsi at their North Carolina headquarters. However, in terms of Pepsi's defense, this is where there's some confusion on how the claim was not responded to properly or in the proper time. The North Carolina headquarters failed to deliver notice to their legal headquarters in New York until mid-September, and then once they did, the secretary for our deputy general counsel, Mr. Tammany, for some reason did not show Mr. Tammany the complaint until early October. The reasoning behind that is there was some confusion. She was prioritizing another event over the papers, and then it just mistakenly didn't get to him. The reason that we ask for the good cause in terms of setting aside the default judgment is based on 4 issues. The first is the policy behind what having this claim not make it to trial does not allow, why it disfavors allowing the default judgment to stand as it is. Because it didn't go to trial, there was no balance of social goals, justice, expediency, or a weighing process that a trial would normally have of the 2 sides of the case. And as we look at the second issue, which is the extent to prejudice of the plaintiff, the excessive amount of damages that have been awarded seem to have a miscalculation or some very, very excessive amount, and Pepsi would like to have that re-looked at and is questioning how the calculations were made. The next 2, the merits of the defendant's asserted defenses and the culpability of the defendant's conduct, go a little bit hand in hand here, and I mainly reference the Hartford case in terms of how the differences of our case and their case compare. Though clearly Pepsi takes accountability for their internal process issues, none of it was done in purpose or with intent to not meet the response timelines as governed by our Federal Rules of Civil Procedure. And secondly, it was clearly a mistake on the Secretary's part, of just a mistake of priorities, of not immediately taking the complaint to Mr. Tammany. But it was not willful, it was not intentional, and it clearly does not rise to the level of culpability that should prevent a court from setting aside the default judgment. At no point is Pepsi not taking responsibility for their fault in not meeting the response timeline, but they are bringing up the fact that this was just a mistake and nothing more than that. The Hartford case is very different. It was sent to the right section and not processed properly or filed properly, which in this case we are not similar in that. It just never made it to the right person to be able to get attention. Thank you for your time, and we hope that you set aside the default judgment.